No one expected Supreme Court Justice Amy Coney Barrett to directly confront Elon Musk during the high-profile hearing. The courtroom fell silent as she pointed directly at the tech billionaire, her voice sharp with authority. "Mr. Musk, your actions demonstrate a pattern of disregard for established legal precedent," she stated. Musk didn't flinch. He didn't respond with bluster or retreat behind his legal team. Instead, he calmly opened a folder, placing it on the table in front of him. The case, Federal Communications Commission v. X Corp., had reached the Supreme Court after months of escalating legal battles. At the center was whether Musk's social media platform had violated federal communications rules by refusing to implement certain content moderation protocols. Justice Barrett, appointed by former President Trump and known for her strict constitutionalist views, had a reputation for legal precision. Her questions were meticulous, her tone unwavering. Musk, seated at the respondent's table in a dark suit and blue tie, had declined to let his lawyers speak on his behalf. He had insisted on addressing the court directly. Legal analysts had warned against the move. The FCC's case appeared bulletproof. Dozens of reports and internal memos showed repeated non-compliance with communication guidelines. The Solicitor General argued that this wasn't just about regulations, but about whether powerful private entities must follow the same rules as others. Barrett began the questioning. "Mr. Musk, your platform has repeatedly ignored formal requests to comply with Section 230 modifications as outlined in the 2023 Communications Act," she said. "Would you explain why you believe your company is somehow exempt from the requirements every other communications platform must follow?" Musk leaned forward. "With respect, Justice Barrett, that's not quite accurate. We've never claimed exemption from valid laws." Barrett raised an eyebrow. "Your actions suggest otherwise. You've received 17 formal notices." 16, Musk replied evenly. Barrett paused. "Excuse me?" "There were 16 notices, not 17, he said. "And we responded, to each one with legal reasoning based on established precedent." Barrett flipped through her notes. "The record shows—" "The record provided by the FCC is incomplete," Musk said, cutting in. His interruption drew audible gasps across the room. Supreme Court justices are rarely interrupted, let alone challenged. Chief Justice Roberts looked up, appearing ready to intervene, but Barrett raised her hand slightly. She intended to handle it herself. Her tone sharpened. "Mr. Musk, this court has little patience for technical corrections that don't address the substance of the question." Musk remained composed. "What you refer to as non-compliance is, in fact, a pattern of constitutional compliance," he said, opening the folder in front of him. "I believe the court will be interested in evidence that the FCC has deliberately mischaracterized our position." Justice Sotomayor exchanged a glance with Justice Kagan. Justice Alito leaned forward slightly. Justice Barrett leaned forward with visible interest. Her tone sharpened, an edge rarely heard from the bench. "Mr. Musk, this court has reviewed the briefs extensively. Are you suggesting the justices have somehow missed critical information?" "Not at all," Musk replied. "I'm suggesting that information was deliberately withheld from this court by the petitioners." The Solicitor General immediately shot to his feet. "Your Honors, this is an outrageous accusation without foundation." Barrett's voice sliced through the chamber. "Mr. Musk, those are extremely serious allegations. Without substantial proof, making such claims before this court could significantly damage your credibility." Musk remained steady. "I understand the seriousness, Justice Barrett, which is why I've brought evidence that the FCC's regulatory demands themselves violate 3 separate Supreme Court precedents, including one where you authored the majority opinion." Her expression held firm, but for those who knew her well, there was the faintest flicker of surprise. "Which opinion would that be?" "Net Choice versus Paxton, 2024, Musk answered, "where you specifically stated that government agencies cannot compel private platforms to adopt content policies that effectively function as government speech controls through regulatory proxy." The courtroom fell still. Justice Thomas, who had remained quiet until now, spoke. "Mr. Musk, are you claiming that the FCC directives fall into that category?" "Yes, Justice Thomas. Musk replied. And I've prepared a detailed analysis demonstrating exactly how. The FCC's lead counsel rose again. Your Honors, Mr. Musk is not a legal expert. His interpretation of Justice Barrett's opinion is fundamentally flawed and self-serving. Barrett was already reviewing the documents Musk's team had submitted, through the court clerk. Her expression didn't shift, but her attention was locked in. Does the petitioner wish to dispute the authenticity of these communications? She asked, glancing toward the FCC's counsel. The attorney hesitated. We would need time to review what's been presented. Barrett looked back toward Musk. You came prepared for this specific line of questioning. It wasn't posed as a question, but Musk responded anyway. I did, because the constitutional principles at stake extend far beyond my company. This concerns whether government agencies can use regulatory authority to achieve what they cannot legally do directly. The tone in the chamber had shifted. What many thought would be a straightforward reprimand had evolved into a much deeper constitutional confrontation. Barrett, ever methodical, continued. Even accepting your premise about the FCC's motives, your platform still ignored legally, issued directives while you prepared this challenge. That's not how our system works, Mr. Musk. Actually, Justice Barrett, Musk said, in Youngstown Sheet and Tube Cumber v. Sawyer, this court established that when facing potentially unconstitutional government directives, parties may seek judicial review before compliance if irreparable harm is likely to result. We filed for emergency stays in 3 separate circuits while preparing our response. Her eyes narrowed slightly, recalibrating her view of the man before her. This wasn't a tech executive bluffing his way through legal theory. Musk had clearly studied the terrain deeply. Those stays were denied, Barrett noted. By split decisions, yes, Musk said. But as Justice Jackson wrote in her dissent in the D.C. Circuit case, the constitutional questions were substantial and worthy of full Supreme Court review. Justice Jackson raised her eyebrows subtly, hearing her own words echoed back in the chamber. The Solicitor General, sensing the momentum shifting, attempted to interrupt. Your Honors, Mr. Musk's legal theories don't change the fact that X-Corp has repeatedly violated clear regulatory requirements. Barrett turned toward him. Counselor, the constitutional validity of those requirements appears to be precisely what's at issue here. Then she faced Musk again. Continue with your argument, Mr. Musk. The moment would be replayed on news networks and social media for weeks. Elon Musk, standing before the highest court in the land, delivering a masterclass in constitutional law that left even his harshest critics momentarily speechless. Justice Barrett, Musk said, his voice calm but deliberate. I'd like to direct the court's attention to page 47 of the materials we submitted. Barrett flipped to the page as Musk continued. These are internal FCC communications obtained through FOIA requests. They show explicit discussions on how to sidestep the constraints imposed by this court's decision in net choice. Barrett scanned the document, her expression growing more focused by the second. These appear to be authentic FCC memoranda, she said. They are, Musk confirmed. Note the highlighted section. Commissioner Thompson wrote, and I quote, while Barrett's opinion restricts our direct authority over content moderation, the technical compliance regulations give us an alternative pathway to achieve the same outcome. A quiet murmur passed through the chamber. Several justices began reviewing the documents with sharpened interest. Barrett looked up, her gaze now intense. Mr. Solicitor General, would you care to address these documents? The government's lawyer hesitated, clearly caught off guard. Your Honor, without broader context, isolated communications like these can be misleading. The FCC's regulatory actions were carried out in good faith and in service of legitimate public interests, Musk interjected. The context is there, in the following pages, including meeting minutes where senior officials explicitly refer to technical compliance regulations as a, quote, useful pretext to pressure platforms into adopting moderation policies that this court already ruled unconstitutional. Barrett turned again to the Solicitor General. Counselor, I will need to personally review these specific documents. They weren't part of the lower court record, Your Honor. the Solicitor General responded. Because the FCC moved to have them sealed. We obtained them just 3 weeks ago, Musk added, through a separate FOIA lawsuit concluded in the Ninth Circuit. Justice Alito leaned forward. Mr. Musk, are you implying there was a deliberate effort to conceal these communications from the courts? The evidence speaks for itself, Justice Alito, Musk replied. The FCC was fully aware its directives ran counter to this court's ruling in net choice. Rather than comply, they sought to circumvent the decision through regulatory maneuvers. Justice Barrett, who had begun the proceedings with visible skepticism, now showed unmistakable signs of judicial engagement. Mr. Musk, she said, your argument isn't just about precedent. You're asserting that the FCC intentionally created a regulatory pretext to accomplish what the Constitution prohibits. Exactly, Justice Barrett, Musk said. And not just any unconstitutional overreach. This was a direct attempt to override principles explicitly outlined in your opinion less than a year ago. The courtroom was hushed. Barrett, now leaning slightly forward, regarded him with renewed intensity. Your Honor, Musk continued, I'm not a lawyer by training, but I've spent thousands of hours studying constitutional law in preparation for this moment because I realized what was at stake. He looked directly at Barrett. When I read your opinion in Net Choice, I was struck by the clarity with which you identified the danger of government using regulatory authority to suppress speech through proxies. Then, quoting directly from her ruling, Musk said, when government power leverages regulatory authority to indirectly achieve what the First Amendment forbids it from doing directly, courts must be especially vigilant. Those words guided our response to the FCC's directives. Silence. Not a shuffle, not a whisper. Barrett was staring at Musk, her expression unreadable but her attention wholly fixed. The FCC's directives, Musk continued, weren't about neutral compliance. They were designed, intentionally, to pressure us into content moderation practices that silenced particular viewpoints. He tapped the documents again. These internal communications make their intent undeniable. Barrett nodded slowly, the weight of the moment fully settling in the chamber. Then she asked the question that could define the entire case. Mr. Musk, if your characterization is accurate, why did no other platform challenge these directives on constitutional grounds? Musk's response was simple, yet it carried immense weight. Because challenging the federal government requires a level of resources and resolve that most companies simply don't have, he said. The easier path is always compliance, even when the directives are unconstitutional. I was fortunate enough to have both the means and the conviction to stand up to overreach when I saw it. Justice Barrett glanced down at her notes, then looked back up. Her tone had shifted dramatically since the start of their exchange. Mr. Musk, your legal reasoning is far more substantive than I initially expected. Coming from Justice Barrett, renowned for her rigorous standards, that statement was nothing short of remarkable. The Solicitor General made one last attempt to regain control. Your Honors, regardless of Mr. Musk's legal theories, the fact remains, XC Corp has failed to comply with lawfully issued directives that every other platform has managed to follow. But Barrett wasn't persuaded. Counselor, she said, if these directives were issued as a pretext for unconstitutional objectives, as Mr. Musk asserts, and as these documents appear to support, then widespread compliance is not evidence of legitimacy. It's evidence of the chilling effect that unchecked regulatory power can have on constitutional rights. In that moment, the government's case began to unravel. What had seemed at first to be a straightforward regulatory enforcement hearing had now evolved into a high-stakes constitutional reckoning. Barrett turned back to Musk. To be clear, Mr. Musk, your position is not that XC Corp refused to comply with lawful regulations, but that it refused to submit to unconstitutional pressure masquerading as regulation? Precisely, Justice Barrett, Musk replied. And we documented every step of our objections even as we were portrayed publicly as defiant or non-compliant. Barrett nodded solemnly, then glanced toward her fellow justices. A shift had clearly occurred. What was once presumed to be the chastisement of a tech billionaire had become a sober inquiry into the limits of government power. The Chief Justice finally spoke. "I believe we need to hear more about these documents. Mr. Solicitor General, the court will expect a comprehensive explanation of the communications referenced here." Musk hadn't just defended his company. He had reshaped the entire framework of the case through meticulous preparation and unexpectedly strong legal acumen. 3 days later, in a rare move, the Supreme Court issued an immediate administrative stay blocking all FCC enforcement actions related to the disputed directives. The legal world was stunned. CNN legal analyst Jeffrey Toobin, live on air, captured the shock. What we just witnessed was extraordinary. Justice Barrett, who was expected to be Musk's harshest critic, essentially validated the core of his legal argument. "I've covered this court for decades. I've never seen anything quite like it." The story exploded across social media and news outlets. Hashtags like Musk Legal Genius and Barrett Musk Showdown trended for days. Courtroom sketches of the exchange were transformed into digital animations that went viral. Former Supreme Court clerks dissected Musk's arguments on legal podcasts. Many admitted they were surprised by their depth and accuracy. "He cited precedents I had to look up," said Yale law professor Samuel Haverford on his podcast. "And I teach constitutional law." Justice Barrett herself remained silent publicly, but insiders reported she had ordered a full internal review of all FCC communications relating to content moderation going back 3 years. The implications stretched far beyond Musk and XC Corp. Other tech platforms, long silent, began to question the directives they had previously accepted without hesitation. Google announced a full review of its compliance obligations, citing serious constitutional concerns raised during Supreme Court proceedings. Meta, Facebook's parent company, filed a motion to join Musk's case as an interested party. Legal scholars began releasing papers arguing that the case could become one of the most consequential First Amendment rulings in a generation. The Harvard Law Review fast-tracked a special issue dedicated to the constitutional issues at stake. Meanwhile, mounting pressure began to close in on the FCC. 3 FCC commissioners were summoned to testify before Congress, grilled over internal communications that had come to light during the Supreme Court hearing. Documents released by X revealed the extent of Musk's preparation. Over 500 pages of legal precedent and constitutional analysis compiled in the weeks leading up to the showdown. Then, just a week after the hearing, the case took a seismic turn. A former FCC staff attorney stepped forward as a whistleblower. "Yes, there was a coordinated internal effort," she confirmed in a televised interview. "We discussed using technical compliance regulations as levers to pressure platforms into adopting moderation policies the government couldn't legally enforce. It was deliberate. We knew we couldn't mandate speech control outright, so we used regulation as a backdoor." The revelation sent shockwaves through Washington. Justice Barrett, once seen as a potential adversary of Musk, found herself unexpectedly praised across the political spectrum. Legal commentators commended her for engaging Musk's arguments with genuine intellectual rigor, setting aside any preconceived skepticism. She demonstrated the exact judicial temperament she promised during her confirmation, one analyst noted. Meanwhile, Musk's public image underwent a radical shift. Known primarily as a visionary engineer and entrepreneur, he was now being recognized as a formidable legal mind. Stanford Law School invited him to give a guest lecture on regulatory overreach and constitutional boundaries, a topic he'd come to embody. Though the case was far from resolved, oral arguments would continue for months, the momentum had clearly changed. Legal experts began predicting a landmark ruling, one that could redefine how far government agencies could go when regulatory power intersects with First Amendment rights. At a press conference following the Supreme Court's stay on FCC enforcement, a reporter asked Musk about his surprisingly deep legal knowledge. "I'm not a lawyer," Musk said with a faint smile, "but when fundamental principles are at stake, you make time to learn what matters. Justice Barrett's writings on government overreach were my roadmap. I just followed the logic of her own legal philosophy." The reporter pressed, "Did you expect to change her mind?" "I wasn't trying to change anyone's mind," Musk replied. I just presented what I believed were sound constitutional arguments. Justice Barrett is known for her intellectual integrity. All I did was take her reasoning seriously and apply it to our situation. As legal scholars pored over the case, many pointed out the irony. The government had brought Musk before the Supreme Court in hopes of making an example out of him, a warning shot to Silicon Valley. Instead, Musk flipped the narrative. Using Barrett's own judicial philosophy, he spotlighted what looked increasingly like an abuse of regulatory power. Perhaps the most telling observation came from a Supreme Court clerk, speaking anonymously, to a legal blog. Everyone expected David versus Goliath, with Musk as Goliath. What we got was a masterclass in constitutional law from someone no one expected to be a serious legal player. The case continued to evolve, but one thing had become clear. This wasn't just about Elon Musk or XC Corp anymore. It had morphed into a national reckoning over the role of government power in the digital age and the boundaries of free speech. And it all began with a justice who tried to challenge a CEO, only to discover he knew her legal positions better than anyone anticipated. If this story opened your eyes to how power really works in America, don't forget to like, share, and subscribe. We bring you the stories the mainstream media won't touch, the confrontations that change the course of history. Hit the notification bell so you never miss the truth behind the headlines.